Few people in the intellectual property industry would deny that patent owners ought to get fair and reasonable compensation when other parties use their intellectual property. But when we're talking about industry standard setting patents, there's simply not one book to go by. Everybody has a different view of what fair and reasonable actually means. On the one hand, you have the innovators saying that they ought to get paid more. On the other, you have the implementers who say that in order to avoid royalty stacking, they should have to pay less. So where does the answer lie?
We were given this, an adapter to use, because my charger for my phone doesn't work here in the US, so I get this in the pack to use in the US, which is a very useful standard, but not a very complex one. On the contrary, where we have not been able to standardize this between Europe and the US.
And the UK for that matter.
And the UK
right?
for that matter,
Yes.
or Austria or Germany. On the contrary, I brought my Swedish phone, and it works beautifully here. Full performance, full interoperability. And it seems obvious to me that companies like Ericsson has no business case for investing billions and billions and billions year after year in developing these technologies that makes our phones work across the world with the same performance, unless there's a fair reward for that. The FRAND system, as we have seen it today, has brought us to an incredibly good spot where we're able to use our phones in any country with the same performance. It's really unrivaled in terms of creating a complex technology that has been globally deployed record fast, created a mass market in no time as compared to anything else. I think it's amazing, and I think I'm for sure going to stay working to keep it that way.
But what we've seen in some of the FRAND litigation is a really remarkable range of disagreement. So in the Microsoft Motorola case, the parties were literally 1,000 times apart. One party said it's worth a couple $1 million and one party said it's worth a couple $1 billion. And we got to be able to get closer to that.
But this will likely lead to more litigation, which some at IPBC Global found problematic, even those who spent years at the heart of the court system.
Litigation basically is a failure of the system. If we're going to do a good job of resolving conflicts of this dimension, we need to find ways to do that outside the court system, I think. And patent pools are one of the resources we have to make that work better.
Patent pools have come a long way, and innovative patent pool administrators like VIA, we look at who we need in the room, and we can work with the licensor. So
Roger Ross brought together various players in the radio frequency ID business in a patent pool in 2005.
we're actually trying to be in front of dispute resolution. You take a very cost-efficient, very simple agreement. You know that you're getting the same terms as your competitors, so it's transparent, it's efficient, and it's very straightforward. So we would suggest that is a precursor and could help eliminate arbitration and litigation.
Arbitration might also not lead to an equitable outcome, because the arbitrator usually tries to find middle ground. Ironically, that might not yield the best results. Director of the Law, Science and Technology program at Stanford University, Mark Lemley, and Professor of Business Strategy at the University of California at Berkeley, Carl Shapiro, came up with a different approach.
One of the things Carl and I suggest is what we call in the United States baseball arbitration, or so-called final offer arbitration. And the idea there is that the arbitrator, instead of trying to find a number in the middle between the parties, has to pick either one side's number or the other's. And what that does is, in a lot of circumstances, it drives parties to be more reasonable. If you take an outlandish position and your opponent takes a more reasonable position, you're going to lose altogether, because the opponent's number is the one that's going to be picked. And so if we could actually try to drive the parties towards a middle ground, then I think we're not going to eliminate uncertainty and we're not going to eliminate litigation, but we could actually get closer towards the goal of getting people paid a reasonable price for their intellectual property without allowing them to hold up.
Just now you described the inventor, the innovator, as being a little bit more idiosyncratic. I suppose it's because they have an emotional attachment to their innovation. Maybe that's the reason. But who do you think is being less reasonable about the debate?
Well, you know, I mean, I think there's plenty of unreasonableness to go around, to be honest with you. And it's funny because when Carl and I did this proposal, we got hatred from two sides. We got hatred from the patent owners who said that's unfair, you're taking away our rights, and we also got hatred from the folks who were on the licensee side, who said, well, we want to be able to take all the benefits of reasonable and non-discriminatory licensing, but we don't want to actually have to do a deal. We don't want to have to agree to pay whatever the license price turns out to be. We still want to fight in court and so forth. And you know, there's a lot of money at stake, and there's a lot of interests that are cemented on each side, and so I think that's why you see these positions that are so far apart. But I do think the goal of whoever's making the decisions, whether it's the court or an arbitrator, has to be to try to move towards a middle ground that's neither I have you over a barrel because it's a standard and now you have no choice, nor is it, oh, because you committed to a standard setting organization, now people can use it with impunity and there's nothing you can do about it.
Patent pools, arbitration, mediation, all looking to reach the elusive goal of fair, reasonable, and non-discriminatory pricing. But in an industry built on defending intransigent positions, it's unlikely the scales of justice will ever fully come to rest. Mark Laudy at IPBC Global in San Francisco.